Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with an important update from the Supreme Court. Advocate Prashant Bhushan today sought an urgent hearing for a contempt petition filed by Association for Democratic Reforms and Common Cause against the State Bank of India for alleged non-compliance with the Supreme Court's order to disclose details of electoral bonds. This move by the two non-governmental organizations comes amidst the ongoing battle for transparency in political funding, particularly concerning the contentious electoral bonds scheme. As you know, that while delivering the judgment in the electoral bonds case, the Supreme Court had held that the entire electoral bonds scheme was against the Constitution and had directed the issuing bank to stop issuance of electoral bonds. SBI was asked to provide the Election Commission of India with information about the electoral bonds purchased since April 2019. But recently, SBI filed an application seeking an extension of the time till 30th June this year to furnish the information. Bhushan today mentioned that their application was likely to be listed on Monday. He requested that this contempt petition be also listed along with SBI's application. Chief Justice of India told Bhushan to send an email request with the details of the application number. Let me tell you, the contempt petition accuses SBI of deliberate defiance and seeks initiation of contempt proceedings. ADR and Common Cause contend that SBI, the issuing bank of electoral bonds, has failed to furnish vital information regarding the bonds to Election Commission of India within the stipulated time frame set by the court. It also highlights the urgency of disclosing information related to electoral bonds. In another important update, a bench of CJI Chandrachud and Justices J.B. Pardewala and Manoj Mishra today heard the SLP filed by Sunil Prabhu of the Shiv Sena Uddhav Balasaheb Thackeray faction questioning the decision of Speaker Narvekar in the disqualification issue. In January, the Speaker had held that Eknath Shinde's faction is the real Shiv Sena following the emergence of this rival faction within the party in June 2022. Not only this, but the Speaker also refused to disqualify any member belonging to the either faction. The court today expressed reservations about the Speaker using the test of legislative majority to ascertain which faction was the real party. The Supreme Court pondered whether this approach of the Speaker contradicted last year's Constitution Bench judgment in Subhash Desai case. Today, senior advocate Mukul Rohtagi continued objecting to Uddhav Sena directly approaching the Supreme Court, invoking its jurisdiction under Article 32 of the Constitution. However, senior advocate Kapil Sibal, appearing for the petitioner, stressed the urgency of the matter and the need for a swift resolution, citing that the Assembly's term was set to expire in October-November of this year. Adding to the discussion, senior advocate Abhishek Manu Singhvi emphasized the distinction between legislative majority and organizational majority post-defection. Ultimately, acceding to the request made by the lawyers for the petitioners for a hearing, the bench posted the matter to 8th April. It also clarified that the question of maintainability has been left open. The bench also summoned the original records placed before the Speaker of the Maharashtra Legislative Assembly while he was hearing the disqualification pleas. You can visit livelaw.in to read about the courtroom exchange in detail. The Calcutta High Court today took up the suo motu motion on alleged sexual assault on women and land grabbing of tribals which took place in Sandeshkhali at the behest of prime accused Shah Jahan Sheikh, a former member of the ruling TMC party and elected Pradhan of the concerned Zilla Parishad. Earlier, the court had directed for Sheikh's custody to be handed over to the CBI in the matter of assault on ED officers in Sandeshkhali in West Bengal who were en route to raid him in connection with the ration scam. Today, a division bench of Chief Justice T.S. Sivangnanam and Justice Hiranyamay Bhattacharya was seized of the suo motu matter as well as pleas filed by various parties on the alleged mistreatment of locals of Sandeshkhali at the hand of Shah Jahan and his people, leading to widespread unrest in the area. The bench, upon hearing the advocates, inquired whether Shah Jahan Sheikh, who was an elected leader of the Zilla Parishad, could continue in his post while being in custody, and whether his involvement in the administrative affairs of the region would interfere with witnesses who wished to depose against him. The bench was informed by Sheikh's counsel that he had not exerted any influence ever since the attacks on the ED officials had occurred on the 5th of January. And presently, being in the custody of the CBI, he had no way to use his position. Advocate General for the state informed the court that while he had been removed from the party, his removal as Pradhan of the Zilla Parishad would have to take place in a democratic manner under the law. The bench has posted the matter for further hearing on 4th April and also discouraged efforts from outsiders, including advocates, to visit the area and further aggravate the situation. And now let me tell you, the Supreme Court today took suo motu cognizance of a rule in the state of Madhya Pradesh which completely excludes visually impaired and no vision candidates from seeking appointment to judicial services. The bench noted that the Madhya Pradesh Judicial Services Examination, Recruitment and Conditions of Services Rule 1994 has been amended, as a consequence of which Rule 6A completely excludes visually impaired and no vision candidates from seeking appointment to judicial service. Senior Advocate Gaurav Agarwal has been appointed as an amicus curiae to assist the court in this matter. Let me also tell you, the Supreme Court in its 2021 judgment in the case of Vikas Kumar versus Union Public Service Commission had overruled an earlier precedent which excluded candidates with more than 50% visual or hearing disability from judicial service. In another update from the Supreme Court, a bench of Justices M.M. Sundaresh and S.V.N. Bhatti today heard human rights activist Gautam Navlakha's plea for shifting his house arrest location in Mumbai. Along with this, the bench was also considering the NIA's plea challenging a Bombay High Court order granting him bail in December last year. Though the bail was granted, it was stayed by the High Court for 3 weeks, which was further extended by the Supreme Court. You already know Gautam Navlakha is an activist and senior journalist. He, along with 15 others, have been accused by the National Investigation Agency of being responsible for the January 2018 caste violence at Bhima Koregaon in Pune. The last hearing of Navlakha's plea was deferred to allow NIA to file a counter affidavit in response to his request for a shift in location. During the courtroom exchange today, Additional Solicitor General S.V. Raju once again reiterated the central agency's concerns over the order of house arrest. He also claimed that Navlakha is now required to pay 1 crore to meet the expenses for round-the-clock surveillance at the location where he is housebound. This figure was, however, disputed by Senior Advocate Nitya Ramakrishnan, appearing for the embattled activist. She argued that the central agency's calculation of the amount payable was wrong and contrary to the relevant rules. Besides this, she also informed the bench that a deposit of 8 lakhs had already been made by Navlakha towards surveillance and security expenses in terms of the court's order in April. She accused NIA of engaging in what she described as extortion by demanding an excessive amount from the human rights activist towards meeting his house arrest expenses. The bench directed the matter to be adjourned to a non-miscellaneous day in the coming April, and the stay on the Bombay High Court's bail order will continue until then. The Supreme Court today issued notice in a petition challenging constitutional validity of the Telangana Hindu Religious and Charitable Endowments Act of 1987. The petition was preferred on behalf of Sri Veerbhadraswamy Temple priests known as the Machaleshwarnath Temple against the state of Telangana. Apart from challenging constitutionality of the act, the petition also challenges orders passed by the Commissioner of Endowments appointing an executive officer for the temple. The petitioners claim that through these impugned orders, the Telangana government is attempting to take over the said temple and remove the petitioners. The act has been challenged on the basis that it gives the government unfettered power, as it can replace the management of any temple without giving any reason. It was further submitted that the government can only take over the management to cure financial maladministration, and thereafter the management of the said temple has to be returned. The bench comprising Justices M.M. Sundaresh and S.V.N. Bhatti issued notice today and also stayed these orders. In another update, the Supreme Court has quashed a criminal case against a man accused of raping a woman on the false pretext of marriage after noting that when the relationship started, the woman was already married and that there was no promise to marry. The bench comprising Justices C.T. Ravi Kumar and Rajesh Bindal overturned the High Court's decision which had refused to quash the criminal case under Indian Penal Code for the offence of rape. The court observed that the respondent woman was a grown-up lady about 10 years older to the appellant. She was mature and intelligent enough to understand the consequences of the moral and immoral acts for which she consented during the subsistence of her earlier marriage. In fact, it was a case of betraying her husband. And lastly, the Wrestling Federation of India, that is WFI, has today informed the Delhi High Court that it will withdraw its circular issued on 26 February to conduct selection trials for the Senior Asian Wrestling Championships 2024 and Asian Olympic Games Qualifier Wrestling Tournament. The court was hearing a plea moved by wrestlers Bajrang Punia, Vinesh Phogat, Sakshi Malik and Satyavrat Kadian against WFI's circular. The plea sought a direction on the WFI to cease and desist from conducting the national trials as notified through its circulation issued on 26 February. Justice Sachin Datta was today informed by WFI's counsel that the circular shall be withdrawn without prejudice to its rights and contentions. The court said that consequently, the trials shall proceed as per the circular issued by WFI's ad hoc committee on 9th February, announcing that the national selection trials will be held on 10th and 11th March. The matter will now be heard on 26th April. Stay tuned. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.